Let's get started. Thank you so much for joining us, everyone. My name is Reed Shaw. I'm one of the co-chairs of the Berkeley Law Consumer Advocacy and Protection Society, or CAPS. Our organization's goal is to promote the study of consumer law and bring speakers and other programming to Berkeley Law's campus. We've had a bunch of events this semester, and we'll have some next semester, so I'll put our newsletter in the chat. We're excited to be joined today by Berkeley Business Law Journal to host this event with Matt Stoller and Prasad Krishnamurthy about corporate power in the 2020 election. Thank you both for being here. Format-wise, Grace and I will start by introducing our guests. Then Professor Krishnamurthy will moderate a discussion with Mr. Stoller about his book and other topics in antitrust. And then we'll try to save the last 10 or so minutes for questions that I'll collect in the chat throughout. So starting with Mr. Stoller, Matt Stoller is the Director of Research at the American Economic Liberties Project, and he's the author of the book Goliath, the 100-Year War Between Monopoly Power and Democracy. Stoller was previously a fellow at the Open Markets Program at New America, where he researched the history of the relationship between concentrated financial power and the Democratic Party in the 20th century. Before joining Open Markets, Stoller spent 6 years on Capitol Hill. He worked on the Financial Services Committee in the US House during the 2008 financial crisis. His 2012 Law Review article on the foreclosure crisis predicted the rise of autocratic political forces, and his 2016 Atlantic article helped inspire the new anti-monopoly movement. His writing has appeared in the Washington Post, New York Times, Fast Company, Foreign Policy, The Guardian, Vice, American Conservative, and The Baffler. And now, Grace, I'll turn it over to you to introduce Professor Krishnamurthy.
Perfect, thank you. So, Professor Krishnamurthy joined the Berkeley Law faculty in 2010. He is a graduate of Yale Law School. He holds a master's and a PhD in economics from UC Berkeley and a master's in political philosophy from the University of Chicago. Professor Prasad's research and teaching interests include financial regulation, antitrust and competition policy, law and economic development, and distributive justice. Thank you so much for being here with us today, Professor.
Thank you.
So now we'll turn it over to you, to Professor Krishnamurthy, to get started on the moderated discussion.
Thank you, Reed, and thank you everyone for joining us today. Thanks also, Matt. It's nice to meet you. I wanted to, start things off with the antitrust topic du jour, and that's the case that the Justice Department filed against Google. And so, Matt, why don't I turn it over to you to kind of give us the background of that case, maybe to start with, and then your thoughts on what the Justice Department has done and what it portends.
Yeah, so it's a big deal. We're going to be talking about history here. I'm looking for a quote from the Pecora, from his investigations in the 1930s, Ferdinand Pecora, who was looking at Wall Street. So he was talking about J.P. Morgan when he said, "The problems raised by such an institution go far beyond banking regulation in any narrow sense. It might be a formidable rival to government itself." And he also talked about how this is a paraphrase, never had so much money, so much power been called to account when he was talking about the core commissions. And we're in a sort of similar moment, I think, with the large technology platforms. So today the government filed an antitrust suit against Google. Largely it was sort of, it's a very, in terms of the case structure, it's very similar to the case that they filed against Microsoft a little over 20 years ago. The government argued that just like Microsoft was engaged in anti-competitive behavior to undermine their rival browser, which was Netscape Navigator, Google was doing that with its tying its search engine to its browser Chrome and its mobile operating system Android, as well as arranging a host of anti-competitive contracts with cell phone companies, mobile phone manufacturers, and browser developers like Mozilla, And the government said this is why Google now has a search monopoly, about 90% of the search market and the search advertising market, about $40 billion of revenue a year in the United States paid to search for, or paid to Google for advertising, and asked for the court to find Google guilty of monopolization, a couple of Section 2 claims, and also asked for unspecified potential structural remedies, which would be breaking it up. So this is a huge deal. It is the first major case, antitrust case that we've seen again since Microsoft. It's the first Section 2 Sherman Act case that we have had from the DOJ since Microsoft. It's somewhat narrow. It's only on the distribution of search engines. It's not on things like self-preferencing, where Google will send consumers to its own properties over those of its rivals. It doesn't include things like on advertising technology. So Google owns a lot of the underpinning of the software that controls publishing and advertising, mapping, things like that. But it's a strong complaint. It'll probably be bipartisan, and there are going to be follow-up suits. Congress itself has sort of been aggressively investigating large technology firms. So 2 weeks ago, David Cicilline, who constantly talks about the conflict between monopoly power and democracy, concluded a 16-month investigation in the House Antitrust Subcommittee and said these 4 companies, Google, Apple, Facebook, and Amazon, are too big and too powerful, and they need to be broken up. It is very much kind of a weird, I don't want to say it's a New Deal moment because the analogies are not perfect, but this is happening in the context of an election, the sort of a rickety democratic systems that are kind of, I don't want to say failing, but there's been a tremendous loss of faith in liberal democracy, and we've seen that before in our culture in the 1890s and then late 1920s and the early 1930s. So there are no perfect analogies here, but a massive set of investigations and antitrust suits calling the kind of shadow of private government into account is very similar to what we've seen in other eras that have, I think, similar, very frightening, but also potentially really hopeful analogies here. So that's kind of how I think about this suit and the election joined together. I don't know if that's helpful, but, and you can't see me, but I am wearing a suit and tie as well. So there we go.
So Matt, if I was to ask you a little bit about some of the charges that the Justice Department didn't bring. For example, in Europe, there has been a much greater concern with respect to Google in terms of exactly what you mentioned, that Google uses its its monopoly over search to steer those who are using the Google.com website to products in which Google has some kind of underlying affiliation, in some sense, sort of tainting the quality of the search. And so those kinds of theories were not pursued, at least as I understand it, in the Justice Department complaint. Do you have any sort of theory behind that? Do you think it's just that the department is trying to make a winnable claim, and there was some weakness to the idea that the search results are being manipulated? At least to me, that actually strikes me as a complaint that could more trigger general public concern than, for example, the one that was filed. That could be something that the public could latch onto as a piece of unfair behavior in the marketplace that actually affects them and affects the things that they are kind of able to see and to acquire when using Google.
Yeah, I mean, there are, the DOJ is following, in a lot of ways, is following Europe. So part of their claim is a claim on Android, which the Europeans already brought that claim. And actually the Russians brought that claim as well. So, but yeah, they haven't brought the self-preferencing claim. The Europeans have brought that, I think, on online shopping forums. online shopping comparison engines. In terms of why I think the DOJ brought this particular claim, I mean, I suspect it's a couple of things. They probably thought that they could win. That's probably the main reason. There is still, from what I understand, and I'm not an antitrust lawyer, but from what I understand, there's still pretty good case law against exclusive dealing arrangements, and these are what the DOJ highlighted are exclusive dealing arrangements, monopoly maintenance claims. I am sure it is not lost on any of them, and Bill Barr came out and said this explicitly. This is very similar to the Microsoft case, and the Microsoft case, the government did win that, and that's a big deal. So I think that self-preferencing, that's not necessarily as easy a claim to win. My guess is that's what antitrust lawyers were thinking in the division, that this is going to take more time. We have to have a more creative legal theory. The other I think part of this is that the DOJ, Bill Barr basically told the DOJ, file a complaint and do it now. Right. And he said that in the summer. And so they probably gathered together the best complaint that they could. They're all probably pretty nervous because, no one knows what I mean, we can all say, oh, this is a good complaint or a bad complaint or weak or strong. But the reality is there hasn't been one in 22 years. So who knows? The law is not, it's not clear what the law is at all. So my guess is that the lawyers are probably gun shy. Their last major case where they got, humiliated was AT&T Time Warner. But they also lost on Sabre, which was a merger challenge. So there are reasons why they would be leery. So they probably wanted a very tight claim. And then Bill Barr probably wants them to bring a case because he wants to bring it before the election, not necessarily for a partisan reason, although maybe there's some of that in there, but just because he's not going to be in charge for very much longer, and he wants the case brought. So that's kind of my sense. But I do think the case is going to broaden. So the attorney generals, I mean, Letitia James, who's the New York attorney general, said that the states are going to be, the Democratic states, she didn't say Democratic states, but there's two groups of state attorney generals. Mm-hmm. One is largely Republicans. That's that's Ken Paxton in Texas. They are studying the ad tech, ad tech stack, which is how advertisers buy online display advertising on third-party websites. So that's not Google. That's like, say, the New York Times or other websites, but all of the underlying plumbing is owned by Google. So Texas and a bunch of states are focused on that. And I think Colorado and New York and a bunch of others are focused on what you brought up, which are the self-preferencing claims that have already been tried in Europe. And they're likely to bring cases within the next, fairly soon, and they are probably also going to consolidate them.
And then if I was just to start to pivot to maybe some of the themes that you had mentioned in the House's broader investigation, which is much more of a I think much more of an openly political event in its focus on the large tech companies and their role in our society. So what do you think? So as the complaint doesn't mention what remedy it's going to seek, but what do you think should be done with Google? And then you could sort of start with Google, and you could then talk about the other major tech companies that were part of the investigation, i.e. Apple and Facebook and Amazon, and say what you think is different about what needs to be done in the case of each of these companies and their outsized role in the economy that the committee finds to be, at least in part, the result of anti-competitive abuse as opposed to quote unquote natural product development.
Yeah, so there's sort of two different questions there. And one is, what can you do under existing law? Mm-hmm. And then two, what is the right thing to do based on one's political values? And one might need to change laws or write different rules in order to get there. So in terms of what's possible under existing law, I'm not sure. I'm guessing that they could probably force a spinoff of Chrome and maybe Android. They could, if they get the right judge and they're able to bring the right case. And you could probably see some, you have the Epic Games versus Apple case, so you could see some changes to app stores And you know, I think there are things that you can do under existing law. Robinson Patman hasn't been used for a long time, but there's probably some ways that you could go after Amazon on that. There are false and deceptive Section 5 authority that the Federal Trade Commission has, where you could start to go after some of the ways that Google and Amazon organize their search engine with sort of pay-to-play results that are not evident. There's a lot of things that you could do under existing law, and but ultimately, what you know, we're probably going to need to have statutory changes. That's what the House Antitrust Subcommittee report came out with. They said we need better enforcement. I mean, the report was really, you know, I think one of the key losers in the report were not these companies; it was the enforcers. So it was a big oversight, even though they didn't say it this way. The report and the investigation that David Cicilline put forward was an oversight report, and they brought a lot of clear evidence that enforcers were not enforcing the law during the Obama era, and the Bush era, and a little bit in the Trump era as well. So part of it is going to require better enforcement. But there were basically 3 buckets of recommendations from that report. One is, you know, reform the agencies and make sure that they start enforcing the law. And that means more oversight, more aggressive oversight from Congress, and also they should have more money and authority. Another part of that is to strengthen private rights of action by getting rid of arbitration agreements and making sure that you can have lower pleading standards. Basically, let private enforcers go after these companies, let ordinary people have their day in court, which has been limited through a lot of procedural hurdles. So get rid of those hurdles. So that's restore enforcement. But the 2 main changes that are not about that would be, one, restore antitrust law. So overturn a bunch of Supreme Court precedents that make it really hard to bring claims on, you know, essential facilities or monopolization claims. Get rid of the special place that multi-sided markets have in antitrust law that's now existed since the Amex decision in 2008. Restore predatory pricing doctrine so that you're not allowed to price below cost just because you have a superior financial advantage. I mean, that law is essentially a dead letter, and is the reason that Amazon was able to become what it was, is they were able to run right through that. Strengthen tying law, because that's a big part of what all of these companies do. And then there's restoring competition. So that's just generic antitrust. Oh, and then there's merger laws. So that's generic antitrust changes that would affect every company in the economy, because it's just the antitrust law applies to everyone. And then there's the sector-specific stuff, which is restoring competition to a highly concentrated tech sector. And the thing to understand about the tech sector is that, in many ways, you know, there's this sort of myth that these companies, you know, were started in a garage and by a genius engineer who built them up, and now they're these, you know, it's a story of American ingenuity and success. That's kind of a false narrative. These are actually financial conglomerates. They are the result of mergers. And they are not the result of great technology. They are financial conglomerates that have captured technology through a host of anti-competitive practices, as well as developed some of that technology themselves. And but now, you know, you have these, similar actually in many ways to U.S. Steel in 1901, which rolled up the iron and steel industry. So in that, you know, one important way to get rid of concentration in these markets is just a bill like the Hepburn Act of 1906, or the Airmail Act of 1934, or Glass-Steagall, just a breakup, just a straight up legislative breakup saying you can't both be a platform for some form of commercial activity and compete on top of that platform. That's just not fair. So that's part of it. Part of restoring competition online. Other elements of that restoring competition online include mandating interoperability. So this is similar to things like, I guess, Carter phone or CPN. I forget what they're called, but there are certain interoperability requirements for phone networks, and then non-discrimination standards. So this would be sort of something similar to like net neutrality, but applied to Google or Amazon. So you'd have to give the same terms and conditions to the same. If you're one class of customer, you get the same terms and conditions that you do as the same ones as any other class. So those are sort of the three buckets, which is restore enforcement, both public and private, restore antitrust law, both monopolization and merger law, and then do sector-specific rules that are basically structural separation and non-discrimination principles so that the online sector is once again competitive.
So Matt, what do you think about, there's a sense in which there's a bit of a choice to be made between, now we're putting ourselves well beyond the law, but firmly in the realm of a plausible policy. And I'm saying there's a kind of choice to be made between a separation paradigm and a non-discrimination paradigm, right? I mean, they're not strictly either or choices, but they are choices to be made. And there are costs associated with each of them, right? If you were to have the non-discrimination paradigm, well, non-discrimination would never be enforced perfectly, and you would still have, if you would have large vertically integrated firms, simply the market presence of the firms in upstream and downstream markets would generate a certain element of foreclosure. So those are costs on the kind of the non-discrimination side. On the structural separation side, the costs potentially are that often firms that are good at in product A innovate in complementary product B, right? And if you are going to say from the beginning that if you ends up that you're a firm that's good at A and good enough to get some level of market power that would be designated by an antitrust law to be sufficient enough market power, you can't be in product B. Then the cost would be potentially chilling all of the innovation that happens when firms end up producing a product that's adjacent to the one they currently produce. How do you think about those sets of trade-offs when you're thinking about policy in this area?
Yeah, I mean, I think that for the first one, I would say I think you need both structural separation and non-discrimination. These are large, complex, vertically integrated companies. They're basically lawless, and you can't regulate. Non-discrimination is just not going to work in the current paradigm because they just won't obey the law. They just haven't obeyed the law. You can just see that. So you have to split them up and break their power and radically simplify the market structure. But once you do that, I think non-discrimination is a lot easier to enforce. For example, Amazon has its fulfillment by Amazon operation, which is essentially looks like FedEx. They also have their retailer, which looks like Target. And then they have their marketplace, which looks like eBay. If you split them all up, it's not that, eBay has an incentive to offer everyone the same terms. They do that. So, the regulatory, it's not that hard to get eBay to obey non-discrimination principles. The same thing with FedEx. I mean, they don't really treat, they basically treat packages the same, and it's not that hard to make sure that they're doing that. But, if you combine them all into one corporation, which has all sorts of incentives to self-deal, then the regulation becomes much harder. So I think that the structural separation and non-discrimination principles go together. I just don't think that we can't regulate these corporations. They're just too big and complicated. They can't even regulate themselves. They don't know what they're doing most of the time. On the second point about, chilling innovation, I really think that's more of a theoretical problem than anything else. I don't see a lot of evidence that that large corporation. I mean, if you just go back, we've had sector-specific regulatory constraints, and I just really has not chilled innovation. I just don't think there's a lot of evidence for that. So, what is much what we do see right now is that venture capitalists just will not invest in any areas that are in the bullseye where these companies are, or in any areas that are adjacent where these companies could move into. If you have a great idea to do something about online shopping, and you go to a venture capitalist, the first thing that they're going to say is, well, where is Amazon in this? And that's just, online shopping. That was 10 years ago, there would be no way to get investment, let alone today. So I think that, you have what are called kill zones across the kind of internet economy, increasingly across the whole economy. So
if I can interrupt there, that's a question about Amazon's power in one particular market, right? Vertical separation wouldn't do anything to touch Amazon's market power in online sales. So it would be horizontal breakups, right? That would address this problem with the venture capitalists, correct?
I'm sorry. Let me put it a different way. If you constrain AT&T in 1956. So the AT&T consent decree in 1956, when it broke up the company, it had them sell off a bunch of their foreign subsidiaries. But it also, they also said you can only do telecommunication services. You can't go into electronic computing. You can't go into software. So that had a number of impacts. One of them is that they also said you have to license your patents on a non-discriminatory basis. So AT&T ended up licensing their patents for Bell Labs. One of them was something called the electronic transistor. They also ended up, there were a ton of patents that got licensed and used by companies that might not have been able to do that had AT&T not been forced to license that information. But also, one of the more interesting things that you saw is that largely the companies that started and licensed patents did so outside of the telecommunications space. So they didn't try to compete with AT&T where AT&T was dominant. Instead, they competed with each other outside of those spaces, sort of adjacent to AT&T. And I think when you saw AT&T try to get into the computer industry after that consent decree was lifted in the 80s, they did a really bad job because they weren't very good at making computers. And I think this is what you see. Like, there is just not a lot of great innovation. I mean, there's some innovation, but if you actually just force what are essentially public utility style services to focus on those services, innovation happens. It just doesn't happen from within those companies, and often the innovation can be better, more, and produce better products. So that's kind of the way that I look at it. And I really think that the fear of chilling innovation in adjacent spaces is a little bit overstated.
Well, I guess I think that the pushback, I think, from the other direction would look something like, look, you have many countries who are engaged in intensive industrial policy to try to create companies like Apple and Google and Facebook and so on. And what we should be doing from the standpoint of domestic policy is having them attain whatever, they're not just national players, they're global players, but having them attain that, the attainment of that global scale is potentially a domestic good. All you have to do is figure out the right way to sort of tax the returns to that company to benefit you domestically. So it's the worry that you are, that one is, most economies are not innovative, right? And the danger that one ends up kind of killing the goose that lays the golden egg is always going to sort of hover over these questions of what to do with these tech platforms, which are world beaters, right? They're not just
well, but again, I mean, that's sort of falling into this narrative that I think is false, which is that these guys created all of this wonderful technology. That's not what happened. These guys captured technology. I mean, Google, their innovation was called backrub in the late 1990s. It was the backlinking. And then they were the first ones to really figure out how to use, data as an input back into search. But largely what they did post 2002 was they bought everything. So it's not like they invented all of these technologies. They largely bought them. And you can look at, so another way to look at it is these guys are actually not very good at what they do. They are good at strategy and using market power, but there is a reason that TikTok came from China and not the US. We used to have a TikTok, it was called Vine. until Facebook actually killed it. And I think you could make the same argument about
So would that,
Boeing in
here, just
2018, which,
so would that be
hang on,
true
let me just.
Sure.
In 2018, Boeing was this dominant corporation. They had $100 billion of revenue for the first time. If you said Boeing wasn't doing a particularly good job building airplanes, like, you'd get laughed out of the room because it was so powerful. But market power of Boeing, their political connections in their defense industry, and the market power in the commercial aerospace industry was actually masking the underlying deterioration of productive capacity, which is the same thing you saw in the auto industry in the late 1960s when American car companies, no one could imagine that those would be, they were the best, GM, Ford, Chrysler. And then, but it turns out that was market power masking the underlying deterioration in the productive capacity of these corporations. So I think when we're looking at large corporations like Google, Facebook, Amazon, Apple, it's easy to look at them and say, wow, they're so innovative, they're so great. But in fact, it's more likely that they're just dominant because they have market power, and that is actually masking the underlying deterioration of their productive capacity, because that's what always happens with monopolists.
It's certainly the case that if you look over industrial and commercial history, companies that succeed eventually fail, right? There's no such thing as a company with, they're not like states, and even states are not like states. They don't have infinite lifespans, right? And and I think the question for innovation policy is something like, at what point do we begin to understand that the innovative forces are less the drivers of the company's comparative success, and the incumbent market power, the greater percentage, and at that point to sort of intervene in the process of exiting or limiting their kind of market power. But that's always sort of that's kind of always done against the backdrop of understanding that there were innovations that put them in that position in the first place, and sort of thinking ex ante about how we try to balance those things against one another. I do think that it's an open empirical question whether something like strong separation principles across the lifetime of firms, whereby acquisition of market power in market A would mean that you could not enter market B, would enhance or retard innovation. I mean, I don't think that's a question easily answered, but I think that is the kind of policy question that's on the table.
I actually don't agree with that. First of all, I just have two basic conceptions, ideological. First of all, this is not a question of just empirically, can we just design the best policy? This is just a political question, right? And I mean politics in the grand sense. What kind of society do we want to live in? Is this a society where you want the massive global centralization of the flow of information so that you can either have, your information provided and sculpted by Mark Zuckerberg, or Alibaba, like, is that, or Tencent, whatever, like, is that the kind of world that we want to live in? Or do we want to live in a world where we have local publishers and local voices? I mean, this is just political. Like, what kind of society do we want to live in? And I think when you see that we've never had anything like the massive centralization of the flow of information, both, Amazon's monopolistic books, the Google and Facebook are increasingly controlling the flow of news. I mean, can democracies survive when you have this level of concentration? I think the answer to that is no. So I think we're going to have to address this, and that's just a political question. But I would also say, I think it's an open and shut case on innovation. Like, innovation just collapsed in the early 1980s when we got rid of antitrust policy. That's when Reagan rolled it back. That's when all the corporate labs went away. Corporate labs emerged after the Sherman Act and more aggressive antitrust prosecution, because big companies couldn't buy their competitors, and so they had to set up corporate labs to actually do to actually build and invent things, because that's the only way to compete. So I think that the answer is, like, empirically, like, it's it's done. Like, we figured it out. We understand that these guys, large corporate entities who have market power, abuse that market power. You know, the best, the best reward for a monopolist is a quiet life. They don't want change, right? And they want to deploy technology only when it suits them. If you have market power, that's what you focus on. So I don't think that these are open questions. I don't think there's a debate anymore. That's what we're seeing in our politics. Like, these are done conversations. And now the question is, what do we do?
You know, I guess I would agree and disagree. I mean, I absolutely agree with you. There are political dimensions to these questions that exist, irrespective of you know, what was the technological history of Google search algorithms or the Chrome operating system, and whether it was well developed by whether it was expanded in an efficient way by Google or not. Those are orthogonal to some of the questions that we're asking about Amazon and Facebook and their relative power. I don't think, you know, as someone who keeps track of the economic history literature, you know, I don't think these questions are so open and shut with respect to size and scale of firms and what are the important drivers of innovation in the American or in other economies over time, because this is a global question. Most countries are not OECD countries and are trying to become them, and the role of I don't think the many countries have pursued that path through a very tight relationship between government and business and scale, and ignoring small firms and rewarding labor, and so the history of East Asia and things like that look quite different from the history of England. So I don't think we have really good answers to those questions. I see we're at 1:45, and I think we have monopolized quote unquote the conversation thus far. Let me open it up to our folks who are here, and I think, Reed, are you going to handle this because you've accumulated questions in the chat room?
Yeah. So if folks have questions, they can throw them in the chat. I have one already, and sort of bringing the conversation to the theme of this event, the theme of the organization putting on the event, like the consumer rights movement. So I read your book, Matt, and it does talk a lot about the consumer rights movement starting like in the 70s. And there's no secret that Berkeley and CAPS have a long running connection to the consumer rights movement. And I sort of wanted to ask you if you could talk a little bit about some of the perspectives in your book for the sake of the folks who haven't read your book, and then sort of let us know what the consumer rights movement should be doing now, given our past sins.
Yeah, so it's so my book is an intellectual history of the 20th century, where I talk about the formation of corporate America in sort of the merger wave of the 1890s and early 1900s, and then the ideological battles between Woodrow Wilson and Teddy Roosevelt, Brandeis, and so on and so forth, up into the New Deal. And I really wrote it because, so the first half is sort of how Americans figured out how to deal with the robber barons, and it has there's World War II, and there's an element of fascism in there, and you can see today there's monopolies everywhere and sort of echoes of Mussolini and throughout the world. But the second half is so after the robber barons, Americans broke the robber barons in the 1930s and 40s. What happened to let them back in? And the consumer rights movement plays a big role in that in the 1970s. And so there's this Anglo-American tradition, you go back to the 1600s and you roll it forward, of just monopolization being a threat to liberty, with a lot of different implications about what that means, a lot of racialized implications. But that was the tradition. You could see it in the Boston Tea Party against the East India Company monopoly, or you could see, people just talk about slave owners as the land monopolists. It's really fundamental. And but in the 1950s, a couple of historians and economists told a different story about this tradition. So this is Richard Hofstadter at C. Wright Mills, Daniel Bell. They put together what was called consensus history. And then John Kenneth Galbraith, who's an economist at Harvard, he told a different story about economic development. And what they said is, in fact, this anti-monopoly tradition was a sort of a fantasy of a bunch of aggrieved, waspy farmer populists in the 1880s and 90s who were, in fact, just worried about immigration. And they had status anxiety. And so they told the story. Meanwhile, big corporations and banks and railroads were just what happens in society. It's progress. And there is no political power involved in banking or corporations or railroads. It just sort of happens. And in the 1950s and 60s, the young, large generation kind of grew up on Hofstadter and Galbraith, and they were beautiful writers. And so they learned that America was just endlessly wealthy, and corporations, big corporations, just produced jobs and wealth and great stuff automatically. There was no political politics involved there. There was no power involved there. There were no ideological disagreements. And so this generation focused on things like the Vietnam War, which was deeply immoral, and civil rights and environmentalism, a whole bunch of things that were really important, gender relationships. But they didn't really think about market structure. Instead, when they thought about political economy, it was more a little bit of labor rights, some taxing and transfers, and then consumerism. So the ideological conception of the anti-monopoly movement was producer-oriented or citizen-oriented. And in the 1970s, and this is a Galbraithian frame, but Ralph Nader took it and turned it into the modern consumer rights movement, we became consumer-oriented. And in large part on the left, they sort of argued, oh, well, it doesn't matter. Like the traditional distinction in the Democratic Party was between big business and small business. Democrats were like, we're for labor and small business against big business, monopoly, and finance. And in the 1970s, the consumer rights movement, which was really grew up, these boomers kind of grew up on this Galbraithian and Hofstadter narrative, said, actually, it doesn't matter if it's big or small. The only thing that matters is if the consumer is getting a good deal, right? And so what the first generation of kind of Watergate baby Democrats in 1974, that's when they were elected in response to Watergate, some of the first things that they did is they got rid of rules that restricted discount and chain stores. And immediately you saw Walmart, which was a fairly small company at the time, just explode. So in 1970, Walmart had, I think, $30 million in revenue. 1980, it was $1 billion revenue. 1985, Sam Walton is the richest man in the country. And this is really the sort of the consumer rights movement. Ralph Nader was heavily focused on deregulating airlines, deregulating trucking, deregulating banking. I mean, this stuff came, weirdly enough, a lot of it came from the left, who they believed that there was this collusive arrangement, regulatory capture between regulated industries, the regulators and the regulated industries, and that consumers were getting the short shrift. And this concept that, big labor, big business, and big government were all in collusion together. And so you kind of got to go after them. And small business doesn't exist in their framework. Small business is just another variant of big business. So, you roll that forward for 40 years, and you have all of these people in both parties who are like, look at how great the world is. Airline tickets are so cheap now, and you've got all this cheap stuff through Walmart and Amazon and chain stores, and everything is really efficient. Google, look, their tools are free. Facebook, their tools are free. Amazon has cheap stuff. Like, this is the ideal, because they're thinking about people purely as consumers, not as citizens who want to participate in their economy, or as workers who want to have some control over their work. And so ideologically now we're in this very strange moment where this, the consumer rights, sort of consumer welfare, strange mishmash of pro-monopolist, kind of conservative, like Robert Bork, antitrust people, and consumer rights people who only think about consumerism and low prices. They kind of got what they wanted in a lot of places, although obviously not everywhere. And it's a disaster, right? You have all of this market power everywhere. You have local communities getting ripped apart because they have no social fabric anymore. And so now you're seeing this pushback, and this Google case is part of this ideological pushback where, people are saying, and the anti-monopolists are saying, no, this strategy of the sort of 1970s new left counterculture consumer rights movement was wrong. We have to think of ourselves, yes, partly as consumers, but mostly as citizens, as workers, as people with a stake in our society. And that means that we have an interest in market power and market structure. And now some of the more exciting stuff in the consumer rights world is in really kind of going back to linking consumer questions to market power questions. And I think there's some young, exciting advocates at the Federal Trade Commission who are starting to do that again. But it's an incredibly exciting time, but we're also seeing the collapse of this kind of older 1970s ideology.
Great. I've got another question from Bogdan. He says, after the House report, do you expect the agencies or state AGs to bring cases against all of the big tech companies? And what factors are these groups balancing and what cases to bring? Will they bring any that are unlikely to succeed?
That's a great question. I think you're going to see cases against all of them, but they may not all be in the United States. So one of the weird things about antitrust is that the U.S. is kind of seen as the intellectual leader. I mean, the Europeans pretend otherwise, but they haven't really done anything particularly serious. And they're all kind of waiting for America to give them permission to go after these giant American tech companies. And now that Congress has acted, and now you're seeing this Google case, it's going to empower enforcers all over the world to say, yeah, we have a problem here. This is a market power problem. It's not just protectionism against American companies. But what I hear is that, so obviously you had the Google case today. There are going to be a couple more Google cases that have come from state attorney generals. The rumor is that there's going to be a case against Facebook coming out of the Federal Trade Commission fairly soon. They've been under investigation by the Federal Trade Commission. And then I don't know when, I mean, Amazon is you already saw some things about Amazon in India. You're seeing investigations over Amazon in Europe. I suspect there will be antitrust cases against Amazon in the next year or two in the US, or at least investigations. And then Apple, you already have private litigation with Epic Games. So I don't think that Apple's sort of the easiest one to think about. So yeah, I think they're all going to get hit with suits. I think they're all going to get hit with regulations that may cause them to split apart, or in the next 5-10 years, probably statutes, I think, similar to some of the ones I mentioned earlier with the Hepburn Act and financial syndication rules and so on and so forth.
Awesome, thank you. We're coming up on the hour, but I want to get one more question in from Avery. He asks, tech companies have been increasingly politicized and face attacks from both the left and the right, but they obviously look different, these attacks. How do we make sure that the antitrust policy doesn't turn into a political weapon?
Yeah, I mean, antitrust policy is, you can use it for fascist ends if you want to. I mean, it's a powerful sword, So I think that you want to make sure that you're focused on the process of competition, like the competitive process, and not using the authority to go after your political enemies. And that's the big, largely the concerns are similar, I think, on both sides of the aisle. So the Democrats and Republicans who are concerned about big tech are concerned about it because they think that big tech has too much power in society. They have differences on how they exploit that power. Obviously, conservatives think that a big part of it is to be biased against religious conservatives and social conservatives and conservative movement people. And Democrats have different views on how this power is being abused. But they both kind of see that monopolization is really the key to this arrangement. Now, you do see a number of really bad faith actors that are in many ways working for the large technology platforms. So the Republican Jim Jordan, who's on the House Antitrust Subcommittee and Judiciary Committee, he likes to talk about anti-conservative bias, but he's really doing that to disguise the fact that he doesn't want antitrust enforcers to do anything to these guys because he's actually working for them. So the companies themselves actually want to have the Republicans bring the conservative bias claims because they think that discredits genuine antitrust action. But what you're seeing, and I think this case from Bill Barr, who is, in my view, not a particularly credible guy. I think he lies a lot. I think he does a lot of really dangerous things. But this complaint is really solid. It is well done. It is clearly not partisan. It's very similar to the House Antitrust Subcommittee report that was put forward by Congressman David Cicilline, who's a Democrat. So I'm not that worried about it anymore. I was worried a lot, but I think you're going to continue to see efforts largely by the tech platforms, kind of, as puppets. I don't like being conspiratorial, but they're trying to orchestrate these kinds of arguments because they want it to be partisan, even though in most ways it's increasingly not partisan.
Great, thank you. And now it's 2:00, so I want to thank both of our guests, Matt Stoller and Prasad Krishnamurthy, for joining us, and thank the Berkeley Business Law Journal for co-sponsoring this event. We'll make a copy of this recording available online in case anybody wants to share it. Apologies again for the technical mishaps at the beginning, but thank you all so much for joining.
Thanks.
Hey, thanks so much for having me. I really appreciate it, and it was a pleasure to talk to you guys.
Thank you both.